Good afternoon. Good afternoon. If you'd be able to take your seats, we're going to get started in just a moment. Well, good afternoon to everyone here. Thank you for being here. Welcome. I am William McGivern. I'm the Dean of the University of Minnesota Law School, and I'm thrilled to welcome faculty and staff, students, alumni, and friends, both from the law school and from around the university and around the state, and indeed more widely. Thank you for joining us today, both in person here in the room and also online for this very important conversation. Today, Minnesota Law is honored to host UN Special Rapporteur on Extrajudicial Killings, Dr. Morris Tidball Binns. He's here. He's a medical doctor specialized in forensic science, human rights, and humanitarian action, and he's contributed to the development and worldwide use of forensic science to investigate and document extrajudicial, summary, or arbitrary executions, as well as enforced disappearances, torture, and detention conditions. Over the past 40 years, he has conducted fact-finding, technical assessments, and capacity-building missions in more than 90 countries across all regions of the globe. Welcome, Doctor, to Minnesota at this critical moment, and thank you for lending us your expertise and your insight today. I'm also delighted to welcome Jennifer Pressholt, an alum of our law school and Deputy Executive Director of the Advocates for Human Rights. Jennifer also directs the Advocates International Justice Program, where she supervises the organization's international advocacy at the UN and capacity building training for human rights defenders everywhere. So welcome, Jennifer. Perfect timing. And finally, I want to give a special welcome and thank you to Regent Sam Hines, who is also an alum of the law school, if you're beginning to see a pattern here, a member of our university's Board of Regents, and a longtime friend and supporter of our Human Rights Center. He is joining us online today from California. Thank you to Regent Hines. As we all know, today's lecture is possible due to the efforts of our Human Rights Center here, especially Regents Professor Fionnuala Ní Éireann, who is the faculty director of the center, and Amanda Lyons, an alum of the law school, the pattern continues, executive director of the center. Thank you, Fionnuala and Amanda, for bringing us all together for this important event and many others throughout the year. Here at Minnesota Law, the Human Rights Center leads research, advocacy, and education at the cutting edge of human rights law and practice. The center works with partners inside and outside the university to advance solutions to pressing problems in our state and around the world, and to support both local and global human rights movements. In fact, right now we happen to be in the midst of a new development campaign to raise funds for the Human Rights Center. Did I mention that I'm the dean? That's going to expand and develop and deepen the center's important work. And if you're interested in helping us with that, please let Amanda Lyons know, because I would love to talk to you. Why? Because this is a pivotal time for Minnesota, which has been a long-time global leader in international human rights. Our state has. Our work here at the law school, the deep engagement throughout civil society in our state, and the enduring legacy of the Minnesota Protocol that we will be hearing about today all demonstrate how this is a special place that both faces enormous challenges in this area and is equipped to respond. Recent events only make that clearer, and I'm sure that they will set the stage for a timely and fascinating event here today. So thank you all again for joining us, and I will now turn over to our Executive Director of the Human Rights Center, Amanda Lyons. Thank you.
Thanks very much, Dean. I appreciate that, and welcome everyone. I'm going to make just a few quick remarks, and I might invite Jennifer and Morris to come on up. Or I guess maybe Jennifer, do you want to speak at the podium? Okay, so then we'll wait for our discussion. When we started talking with the advocates about trying to invite the Special Rapporteur to come and visit and have a series of conversations around the Minnesota Protocol, this is maybe more than a year ago for sure, we never imagined that when the visit came to fruition that we would be in the context that we are. Um, it's especially important for us to learn about this tool, but also to come together as we're all, I think, in different spaces thinking about how we can activate international human rights mechanisms and norms and movements and partners to engage with all the activism and resistance that's happening here in Minnesota. So we're very pleased and grateful that you took the time to join us for this today. I would like to, before we kind of move into the conversation about the protocol, just a couple of special thank yous. I'd like to thank Professor Barb Fry, who's here with us, for making the visit and the activities today possible. And also, Barb was lead thinker and drafter and organizer behind the Minnesota Protocol, as we'll hear, so it's great to have you with us, Barb. And we also have 3 other individuals that worked with the advocates, what is now the advocates, to draft the Minnesota Protocol, so I just want to recognize them. They're joining us online today. Regent Sam Hines, who the dean mentioned, and also Dr. Lindsay Thomas, who joined the team that was working on developing the protocol, has joined us, and also a great friend of the center and alum of the law school, Jim Roth. And so we are really glad to be able to count on their presence with us today. And with that, I am going to invite Jennifer up to the podium and to get us started. Thank you.
All right, thanks, Amanda, and thank you, Dean. I am just going to spend a few minutes sharing the story of the Minnesota Protocol, and then we'll hear from our esteemed speaker, the UN Special Rapporteur on Extrajudicial Executions. So I'm Jennifer Prestold. I am an alum, a proud alum of the University of Minnesota Law School, and one of the first things I did as a 1L was I started volunteering with the Advocates for Human Rights. And I remember being in the office. I was working on asylum stuff, but I was in the office and they had these boxes and they were like autopsy report and death investigation. And I was like, what's the story there? And much later I came to learn a little bit more of the story. And it's a story that has its roots in the community here in Minnesota and also right here at the law school with Professor David Weisbrot. So if you think back to the 1980s, it was a time when there was really there was a gap in international law and practice, and there was no way to force a government to do an effective investigation. So there were lawyers here, like some of the folks you've heard, Barb and Jim and Sam, were concerned about the lack of accountability for suspected unlawful deaths that were happening either very publicly, like the assassination of Aquino in the Philippines, or many more deaths were happening in private circumstances in custody, in government custody. But there were no international standards that required governments to carry out an effective investigation. So that gap in the international law and practice really allowed governments to get away with murder. So one of the first projects of the advocates, at the suggestion of Professor David Weisbrot, was to do the research to come up with some international guidelines and really more practical, a manual for how you go about doing these effective investigations. So they brought together local legal and forensics experts, like Dr. Lindsay Thomas, but also national and international experts. And it took a number of years, involved research and many, many drafts. And I think in the Q&A, hopefully there'll be some, if you have more questions about what that was like, you can ask some of the original authors. But the end result were 2 really critical documents. And the first is the UN Principles on Effective Prevention and Investigation of Extralegal, Arbitrary, and Summary Executions. So kind of a mouthful, but that was adopted by the UN in 1989. And this is the international law. So these are the international standards that say when there's a suspected unlawful killing, what needs to be done in terms of prevention, investigation, and legal proceedings. The second outcome of this original group's work was the United Nations Manual on the Effective Prevention and Investigation of Extralegal, Arbitrary, and Summary Executions. Now, that was published in 1991, also a mouthful, so maybe it was no surprise that folks around the world started using the term Minnesota Protocol instead of that long name. Um, so if you sort of fast forward again, we come to 2015, and a lot had changed in the time between 1989, 1991, and it was time to update it. And so I was able to be involved in the update. It was under the mandate of a previous special rapporteur, Christoph Haynes, who was a law professor from South Africa, and Barb and I were both on the legal working group to update it. And Morris, who you'll hear from, was on the forensics working group. I kind of thought that they were the cooler group, honestly, because so much had changed in terms of advancements in forensics and crime scene investigation and so forth. But a lot had also changed in terms of international law advance. And so one of the things that we found in doing our research for the update is that there had been tremendous advances in the rights of families in international law. So the families of the victims of unlawful killings are also now recognized as victims themselves, and they have a right to know what's going on in the investigation, and to know and to have a liaison, to be informed of what's going on. So transparency in that. So that was a change. There's also advancements in the right for society to know what happened, so that those human rights abuses cannot be repeated. And then we also realized that that there wasn't a professional ethics section in the original, and so we needed to include that. So the end result, you'll hear more from the special rapporteur, but in this version, Christoph Haynes, the special rapporteur at the time, was very clear that this time it needs to be called the Minnesota Protocol to honor the work that was done in the 1980s. As part of that update, we also had a team of pro bono volunteers doing research on the impact, and so it was really fascinating to learn how far and wide the Minnesota Protocol has been used. It's been used in litigation from the European Court to domestic courts like in India. It has been used in investigations around the world, from Guatemala to the former Yugoslavia. It has been used in regional bodies like the Inter-American Court and the African Commission. And I think the practice is even more important, and I've seen this in my own experience, that it's used by international organizations and non-governmental organizations or civil society organizations to really push their governments to fulfill their duty to investigate. So I'll share a couple of quick personal experiences from the field. When we were working with the Peruvian Truth and Reconciliation Commission, the team that was working on mass exhumations pulled out, this is the 2016 update, so they had a photocopy of the original, but we're using this, look at this, we're using this, to show that they were using this international standard. Family members and non-governmental organizations told me in the south of Thailand that they bring it with them to the police station to use, to push the government to do what they needed to do to investigate a death in custody. And forensics experts from Nigeria and Tunisia have shared that they bring photocopies of the model autopsy protocol that's part of the Minnesota Protocol, which is based on the Hennepin County autopsy protocol. That they bring those photocopies with them in their back pocket so that they can copy them and use them. So it's a very practical, useful tool for doing those investigations. So that's the story of the Minnesota Protocol, and we definitely want to hear some more from you in the Q&A. But I'll just end it with the fact that the story isn't over. We find ourselves right now in a time and place here in Minnesota where we need to use the Minnesota Protocol in the way that our colleagues in other countries have used it, to to press for the fulfillment of the duty to investigate the potentially unlawful killings that we've experienced here in our own community. So I'll stop there and turn it over to Dr. Morris Tidbald-Vince.
All right. Well, thanks, Jennifer and Amanda. Thanks for making it possible to me to be here today. I'm absolutely thrilled and grateful and honored for this opportunity. As mentioned by Amanda, the visits to Minneapolis on my part has been in the planning for a while now. I think nearly 2 years actually, and we were trying to find a time and moment where I would be coming to the U.S. and so as to allow for some time to jump over Minnesota and spend some time with you and talk about the Minnesota Protocol. It's a tragic irony that that time coincides with such critical moments for the state and for the country, I would say. And that makes me doubly honored and grateful for being here today. Actually, this morning we had a number of meetings already, including with legislators and the governor himself, to talk about ways and means in which the Minnesota Protocol may be of help to your efforts to ensure truth and justice for what you have faced and are still facing in your state. This is my first time in Minnesota. Actually, the reason that brought me to the States on this occasion was receiving an award from the American Academy of Forensic Sciences last week in New Orleans, and then working with the University of Chicago Global Clinic for Human Rights on some academic research to interview death row inmates who were exonerated of the death penalty and hear from them directly what it is like to suffer the death penalty and what it comes to them, which in my view amounts to torture, and which will be the subject of a forthcoming thematic report of my mandate, which I hope to present to the Human Rights Council in June. So I will repeat much of what Jennifer has already shared with you, very much with the philosophy that repetition is the mother of learning. So if you allow me, I will actually speak about precisely the origins of the Minnesota Protocol and its value and implementation. I think it's important to bear in mind two things. One is that this tool is actually the result of a critical moment at a time and place, in particular parts of South America, where I come from. I was born in Chile, grew up in Argentina, two countries which saw brutal dictatorships take away, disappear, and kill thousands and thousands of people, for which the families had no resort of any kind to institutions, the judiciary, etc. And so their only option was to rally the world, to raise awareness, and call for help, assistance to investigate and help prevent these things from happening. This is the reality at the time. Some families were actually just shown a bunch of bones and told that their relatives perhaps were there, and that was it. And why would they trust the same authorities that actually were responsible for these crimes? So, I put this image here because this case actually, back in 1983, very much catalyzed to some extent or helped kickstart the essential contribution of the Minnesota Lawyers Committee to develop the standards that Jennifer just referred to. And it was the murder of Benigno Aquino when he went back to his country in the Philippines and was shot at the airport. And the international community called for investigations, and the question was, to which standards? And that's where the Minnesota Lawyers Committee actually stood up, and we'll actually develop these standards and also address the calls of victims from elsewhere in the world. And among them were a bunch of amazing, incredible, pioneering ladies, mothers and grandmothers of the missing in Argentina, especially the grandmothers, who actually envisioned back in the 80s the role of forensic sciences, or which forensic sciences could play to help them find answers to where their loved ones were. And they traveled the world, they knocked doors. Actually, they came to Minnesota. In this country, with its huge solidarity, there were responses, and the American Academy for the Advancement of Science organized in May 1984 a meeting in New York which convened forensic sciences from around the country in the US to discuss how forensic science could help the quest of the grandmothers. And I'm going to read the precise words of one of those forensic scientists, Dr. Clyde Collins Snow, a forensic anthropologist from Oklahoma, who attended that meeting. And in his presentation, and these are his textual words, he said, "Of all forms of murder, none is more monstrous than that committed by a state against its own citizens. And of all murder victims, those of the state are the most helpless and vulnerable, since the very entity to which they have entrusted their lives and safety becomes their killer. When the state murders, the crime is planned by powerful men. They use the same cold rationality and administrative efficiency that they might bring to the decision to wage a campaign to eradicate a particular obnoxious agricultural pest. The homicidal state shares one trait with the solitary killer. Like all murderers, it trips on its own egotism and drops a trail of clues which, when properly collected, preserved, and analyzed, are as damning as a signed confession left in the grave. The great mass murderers of our time have accounted for no more than a few hundred victims. In contrast, states that have chosen to murder their own citizens can usually count their victims by the carload lot. As for motive, the state has no peers, for it will kill its victims for a careless word, a fleeting thought, or even a poem." And he went on to say, "Maybe it's time for the forensic scientists of the world to heed the old call of our favorite fictional character. Quick, Watson, the game's afoot, and go after the biggest game of all." And so he did, and so they did. And they traveled to Argentina on invitation from the grandmothers of Plaza de Mayo, and that kick-started and triggered a change, I would say a fundamental change in which forensic sciences in this country and elsewhere actually regarded human rights. This was a landmark publication by a leading journal actually dedicated exclusively to the role of forensic sciences to investigate and protect human rights, 1984. And just a year later, Clyde Snow was in Argentina giving testimony in the trial against the juntas, against those military dictators who had killed and disappeared thousands. And his evidence, based on hard forensic evidence, as he had anticipated, helped ensure that many of these men were put behind bars. Also in response to the victims' quest, the United Nations did take action. The first United Nations Human Rights Mechanism as a special procedure established was created in 1980. The Working Group on Enforced and Involuntary Disappearances, composed of 5 experts, appointed in their personal capacity by the Human Rights Commission, today Human Rights Council, and was shortly after succeeded by another special procedure, which is my mandate, which was established in 1982, the first single-person permanent special procedure with the mandate to monitor, document, and report on arbitrary killings the world over, call the attention of states responsible, provide recommendations, develop standards, and help implement them. And as part of the mandate, the newly appointed Special Rapporteur Amos Waco actually was contacted and worked together with these people, with your folk, to develop the standards that Jennifer just mentioned. And these were, sorry, I'm just doing a little parenthesis here. These are my predecessors. So you see Mr. Amos Waco there on the far left-hand corner. Eminent jurists. I'm the first non-lawyer in this position as a forensic doctor. You can find all the information about the mandate in a dedicated webpage. So when I actually was appointed in 2021, I could not actually step into the shoes of my giant predecessors in terms of developing the law, but rather focused on trying to implement or help implement the standards that they had developed in my capacity as a forensic doctor. And one of them is precisely the one that Jennifer mentioned, these principles, which were the first of their kind, which actually provide for and specifically mention the role of forensics in investigating unlawful death. They request, call, recommend that a forensic doctor or specialist be part and parcel of the investigation. They also provide for the rights of families to be informed and participate. These were groundbreaking ideas at the time. Today we take them for granted. But it was a vision of your folk here that actually made it possible to have them spelled out as human rights instruments. And of course, those principles, which are still valid today, are absolutely invaluable, but don't tell practitioners how to implement them. How do you do this? How do you make them work? And so immediately after the adoption of the principles in 1989 by the UN, work was underway to prepare a user's manual, right? That's it. This is a user's manual. So this is not conceived as a manual for the shelves, as a reference in human rights, but actually very much thought for practitioners. These are the protagonists. First and foremost, your folk. One of them is here. Others have already left us. And we have them in their hearts, in our hearts, for all the amazing work that they carried out, like David Weisbrot. And you have a number of forensic experts. You have Clyde Snow there and Bob Kirshner, who was medical examiner at Cook County in Chicago, et cetera, et cetera. The grandmothers participated as well, indirectly with their experience. And then this was published this was published in 1991, Wonderful User's Manual. Now, like any practical tool, from a manual up to the screwdriver, has to be tested. And that opportunity arose soon after when in 1982, the Security Council, one of those rare occasions when everyone got to agree and make a joint decision on something at the Security Council, decided to call for an investigation into allegations of grave crimes in the former Yugoslavia. This is Resolution 780, and among the things the Security Council called for was for a team to go out there and find out whether the allegations of crimes such as the killing of more than 100 patients from Vukovar, a small town in Croatia bordering Serbia, actually was, according to what some witnesses claim, who said that patients were taken away by Serbian paramilitary and never seen alive again, although one witness, a patient, jumped from a truck where they were all being driven out to the fields and claimed that in the distance, all those others were actually shot in the night and disposed of somewhere. So this is what this forensic team was requested to investigate. I was fortunate, privileged actually, to be part of that team, including with Clyde Snow. And we went out there and actually did all that is required from a forensic prospection, meaning search. We found a suspicious area, possible crime scene. It was cordoned. We did some ground testing. We found human remains. We did the exhumation. We examined the remains. We did everything that is required according to the Minnesota Protocol, this new tool. Now, this team was composed of a bunch of forensic experts coming from different parts of the world. Not everyone even spoke the same language. And we had different ways and procedures of doing our forensic casework. And so we had to make sure that we worked to the highest possible standards in a unified manner, and that this would satisfy those who actually were requesting for this investigation, regardless of the results. And that is the beauty of the Minnesota Protocol. It provides for all of that. So it provides you the framework from the legal one up to the very nitty-gritty, practical, how to do a bone examination. all in less than 100 pages. No other UN standard provides for such a valuable, detailed, practical purpose. Perhaps another protocol called the Istanbul Protocol for the documentation of torture nears the Minnesota Protocol, but it, in my opinion, as a forensic doctor, is not as good and valuable as this one. So, success, rubber stamping. Not only the Security Council said, okay, right, now we will do something about this, and went on to create the first ever international tribunal after Nuremberg, which was on the former Yugoslavia. But from a medical, legal, forensic perspective and human rights activist, bingo, we now had a tool which was rubber stamped and approved and tested, which actually served as a model for developing other similar manuals, like these pictured here, and also the Istanbul Protocol that I just mentioned actually is modeled very much on the Minnesota Protocol. And having worked for many years as head of forensics of the International Committee of the Red Cross, it also helped us develop a new field of forensic science, which is called humanitarian forensic action, which is very much framed within the Minnesota Protocol. So there you go. I mean, this is valuable not only for planning and designing investigations, as you may require in this state, but also for developing new tools and ways of doing things, such as in this case. Like any tool, it ages. After a few years, there were calls for the Minnesota Protocol to be updated. I mean, DNA testing didn't exist at the time of the first edition. IT forensics, etc., etc. And so my predecessor, this magnificent, wonderful person who unfortunately passed away too soon, Christoph Heinz from South Africa, he took it up to himself to do this job. And he again reached out to the Minnesota and to a bunch of people, including Jennifer, myself, etc. He proposed doing this in his report to the GA back in 2015, but this was already in the making. And it saw its day actually in 2017. Although it says here 2016, it was actually physically published in 2016, and it is available free, online, in all UN languages and many other languages, because it has been translated, around the world. And what is this about? This is about investigating and preventing unlawful death. And there's three main categories. Those where state agencies are directly or indirectly responsible for a killing. Those that happen when a person is deprived of freedom or liberty, where the state acquires additional responsibility for the life and well-being of the person, meaning that if he or she dies while in custody, the burden of the proof is on the state to prove that there was no foul play, and for which the Minnesota Protocol should be used. It didn't say must. This is not a binding document. Should be used. And then those deaths that occur for a failure of the state to exercise due diligence to protect someone. The classical case example, the woman who is beaten at home, goes to the police, asks for help. She's told, just go back, they will go away. 1, 2, 3, 4 times, and then she dies. She's killed, she's murdered, she's a victim of femicide. There is a state responsibility there. And that case should be also investigated according to the Minnesota Protocol. The most valuable part is contained in 2.5 pages, page 7 to 9.5, which are the elements and principles, or principles and elements of investigation. They should be prompt, they should be effective and thorough, for which you, the investigator, has to have access to all the evidence. and make sure that he or she goes through the whole process of the investigation, leaves nothing outside. It should be independent and impartial. Those suspected of the killing cannot investigate themselves reliably. And last but not least, it must be transparent, meaning there must be a possibility of scrutinizing the investigation, including for quality assurance and control, and most importantly, making sure that the families, the victims, actually receive information. Now, if we look at the cases that you have actually endured recently, the possibility of carrying out a prompt investigation was hampered by interference, the same as effectiveness and thoroughness, because evidence has been withheld. Independence and impartiality, how can you expect a federal agency which is suspected or known to have killed individuals investigate itself? And of course, transparency, that's a big problem here. So you can use the Minnesota Protocol as leverage to call for these elements and principles to be respected. Why? Because while not binding, these elements and principles are grounded based on international human rights law. And I would say hard law in the sense that much of it is of a conventional nature which most countries, including the US, have signed and ratified. So it's the law of the country. So much so, well, by the way, the Minnesota Protocol, apart from all these elements and principles, drives, leads, helps the investigator from the police, the attorney, even the judge, go from the scene all the way to the autopsy room, ensuring care and attention and communication to the families, an ethical framework, et cetera, all the way up to the report for different specialties. And going back to what I was saying before, the grounding of all this in hard binding human rights law also implies that a failure to investigate properly one of these killings may amount in itself, just a failure, to a violation by a state of its duties to protect life, meaning a violation of the right to life. This is hard stuff. I mean, this is spelled out in the Minnesota Protocol. Like the first edition, the second is also regarded, and even more so, as a gold standard. The Human Rights Committee, which actually oversees implementation of the International Covenant on Civil and Political Rights, which the US actually signed and ratified in 1992, calls for every death investigation to follow the Minnesota Protocol. So this is a, boom, rubber stamp from the highest conventional body in the House. This new edition has, as Jennifer explained, new chapters. I would say one of the most important ones concerns the rights of families, another one on ethics that should guide these investigations. It also has broadened its scope of action from strictly human rights law as a first edition to incorporate international humanitarian law. So it's applicable in situations of armed conflict where that exceptional rule, body of law applies. It is also, I remember with the discussions we had and agreements we made with Christoph Heinz and the team to make sure that this also is a tool for investigating enforced and involuntary disappearances. And it has a chapter to document torture post-mortem, which is quite often a very important piece of evidence in unlawful death. And this is an example from my country, Chile, where this has been incorporated into the practice through provisions both from the Supreme Court and the General Prosecutor in daily practice, including of the medical legal services, and it has proven invaluable for the search, recovery, and identification of the disappeared from the Pinochet regime. As you may have gathered, I have actually, as a forensic doctor, I've been working on this for a few years, and through my professional career, I have used both the first and the second edition, and I can give testimony of how valuable, I would say invaluable, essential most of the time this tool is, both for planning and implementing forensic investigations into death and disappearances, especially when the cases are complex, large, and very sensitive. And when I actually tour the world campaigning for this to be used, I always remind stakeholders, especially states, that this is not only about human rights, but it's also about the rule of law. And this is quite important, a very important and quite often useful sort of advocacy approach, especially in contexts where the concept of human rights is not well known or resisted, but it is a fact that this is an invaluable tool for investigating any death, wherever. So, as I said before, I made a vow with a mandate when I was appointed in 2021 to help implement these standards. And I made a motto, implementation now, and that's very much what guides many of my recommendations, press releases, submissions to governments, both in general and in specific contexts like the Ukraine, Bangladesh recently, even the United States of America. Okay, so this is a constant campaigning on the part of my mandate, but that's not enough. I mean, in my experience, what is important is to have this grounded in practice. And how do you do that? It's not just about recommendations. So this needs to be there needs to be an ownership on the part of the users for it to actually be implemented. And that requires training, specialized training. And there's a lot of that kind of work, which is part of my mandate's activities, but also sometimes adapting the Minnesota Protocol for specific contextual needs. So these are examples, sorry. One is some training on the Minnesota Protocol done for prosecutors and judges in Argentina. And this other is an example of a manual developed very recently in Spain to investigate custodial death based on the Minnesota Protocol. So these are the things that actually help this to be actually put into practice. And it's not only about authorities and investigators. I also make a point about training and raising awareness among those directly affected. So this is a section of training for families of unlawful killings by the Brazilian police, families in Brazil. So they can actually monitor investigations, and with this tool in hand, leverage their reclaim for truth, justice, and reparations. And often training and having nice little manuals adapted to local needs is not enough. Sometimes there is a need for a regulation, a law which actually mandates, requests, demands that certain types of killings are investigated according to the Minnesota Protocol. This is an example from a federal country, Argentina. One province actually legislated. It's not a legislation, it's a resolution from the General Attorney's Office of that province, mandated that every potentially unlawful killing be investigated in accordance with the Minnesota Protocol. And then, of course, there's a technical advice, going to the field and working hand in hand with the stakeholders, as I did a couple of years ago with the Ukrainian colleagues and friends, forensic doctors, prosecutors, judges. And we decided first and foremost to translate this into Ukrainian and then have proper hands-on training and capacity building to document the horrors that they're living through. And I repeat, the horrors that the Ukrainian people are living through. This is another case example of the Philippines, a country with a long history of extrajudicial executions by the police. No one actually ever noticed that there is no forensic capacity in the country. So we went down there and did an assessment which confirmed this, and then planned, with the support of the UN, a project to build up that capacity, including with trainings. And that led to the Philippine government acknowledging that this was valuable, and they made a pledge during the 75th anniversary of the Universal Declaration of Human Rights, saying that we will build a proper medical legal death investigation system based on the Minnesota Protocol. Minnesota, 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 Minnesota. The world knows more about this protocol than people in Minnesota. Okay? And what happened here in the Philippines? That pledge was honored. So the president said, yes, this will happen. And that led to the building, well, the founding of the first ever Filipino Medical Legal Death Investigation Institute, following the guidelines of the Minnesota Protocol. And there are other initiatives like regional ones in Malaysia, where the government is happy to host a regional hub for promotion and training of the Minnesota Protocol. Now, this is what is required beyond recommendations and standards. I mean, the real hard work starts after. And we come back home. And, we were all shocked in the world by what happened here. And I was studying the governor's office this morning. The world is both inspired and grateful to the people of Minnesota for how you stood up against this injustice and calling for justice and calling for the rights of the American people, your human rights, which are our rights, everyone's rights. And so for me, it is an honor also, as Special Rapporteur, to assist in your efforts, including for calling for proper investigations into these cases. A meeting with the governor's office today, for which I'm grateful to those who invited me and made it possible to be here today. And I go back to the grandmothers. I owe them being here today, because actually they lured me from being a rural doctor to being a forensic doctor and engaged in human rights. A couple of years ago, with Anjali and the team in the University of Chicago, we actually organized an event which actually honored the grandmothers' contribution to forensic science. Packed full. What a wonderful meeting that was. Food for thought, Jennifer. And actually, last year, the American Academy of Forensic Sciences awarded the grandmothers of Plaza de Mayo, who are not forensic scientists, for their contribution to the development of forensic sciences applied to human rights. And I do believe that we owe them, apart from you guys, having this today, invaluable tool. Thanks a lot. Thank you very much. That's it.
Okay, we have 2 minutes. So, quick questions.
We have one question here.
Yeah. Okay. Well, thank you for obviously your words, Doctor, and Jennifer, and everybody for coming here. My question is more of a, as somebody who's experienced a lot of these moments in time that uh, states have thoroughly abused their power, what would be an effective call to action for you, for us as a community in the city, but also as students, for example? A lot of us here are in a very privileged position and have uh, the ability to act upon what is happening here. Um, Obviously limited, but as civil society actors and as students, what do you think our best like road forward is in terms of action?
Well, thanks. Well, I had the privilege of meeting Alex before coming to the room, and apart from that privilege, I was very happy to learn that we share the same football team as supporters. Yeah. Well, thanks for the good question. I do believe you mentioned the word privilege in the sense of the opportunity that exists now within the mobilization of civil society in Minnesota to actually precisely contribute to even innovative ways of dealing with what you have faced. And the fact that there is right now a discussion on how precisely to frame what it could be, a truth commission, a commission of inquiry, it's still not defined, and act upon it as a model, well, first of all, as a tool for truth, justice, and reparation in this state, but also as a model for other states which are looking at Minnesota and its initiatives, and other countries as well. I think it's a privilege. And I know that the law school and the center and the advocates are actually part and parcel of this discussion. So Jennifer, Amanda, they accompanied me to these meetings this morning, and this is work in progress. So I think the door is open there for creative thinking, maybe even visionary thinking on the lines of the grandmothers. But definitely, I think the opportunity is there. One thing I mentioned, humbly say, well, if whatever structure is established, I do believe that it would be nice and perhaps even useful, some would argue indispensable, that it somehow enshrines or reflects the elements and principles of the Minnesota Protocol. Not only for investigating deaths, but also any other human rights violation perpetrated against the Minnesota people. To have mention of the Minnesota Protocol in the structure or initiative would be very, very useful also as a pedagogical and promotional tool. Wherever you go in the world, make sure you bring a copy of the Minnesota Protocol and you say, I'm from Minnesota. Oh, wow, you probably have your doors open there. So I think it's time to put it into action here. And you have an opportunity. I can't tell you exactly how. And what I did offer is my availability as mandate holder and with some of my experience, if required and when required, to sit down and figure it out from my perspective and angle. But I think you have the best people around here to actually figure it out. But the opportunity is there with the full support of the government in the state. So, did I answer your question? Yes. Okay, thank you.
Well, I just want to say thanks everyone for coming. I guess just one quick thing, the Advocates for Human Rights is a volunteer-based organization, and so please keep an eye on our website as we have opportunities all the time for providing legal representation to asylum seekers, and as we move out of crisis and into, maybe long-term accountability and reform, hopefully we'll have additional opportunities. But really, thanks everyone for being here and for sharing this time with us. I'm looking at Amanda. Do you want to say anything? Okay, then I will say, on behalf of the Human Rights Center, as well as the Advocates for Human Rights, thank you for coming.